Good afternoon, everyone, and welcome to Long Island Board of Realtors Wednesday webinar. My name is Mary Ann Monteleone, Director of Education for LIBOR. Today we have a special guest with us, Linda Lugo. I'll tell you just a quick little intro of her, but I wanted to tell you about her subject, which is dispute resolution. It's a viable alternative to litigation and one of the top reasons why realtors belong to their association. So let me tell you a little bit about Linda, turn it over to her, and she'll talk to you about so many options other than litigation should the need occur for you. Linda is a past president of NYSAR and LIBOR. She serves on professional standards at LIBOR since 1997 and at NYSAR and NAR in that capacity. And she's a mediator and an ombudsman. And if that term is unfamiliar to you, you will learn about it in this webinar. So thanks for joining, and I turn it over to our friend Linda.
Great. Thank you, Mary Ann. Good afternoon, everyone. Thank you for being here today. I appreciate your time. We're going to be going through dispute resolution, and it's a member service at the Long Island Board of Realtors, and I hope that hopefully you'll never need it. That's the first thing. But I think it's very important that you are aware of the services that we have available to you. So, what is dispute resolution? We're going to go through actually the committees that we have and what each one does. We have the grievance committee, professional standards committee, and then we have individuals trained as mediators and ombudsmen. But before I go into the committees and what each one does and what dispute resolution is all about, let me show you two other things that I think are very important. The first one is our code of ethics, which you should all be familiar with. This is our code of ethics. This is the one that's effective January 1st of 2024. It has our 17 articles. It is 8 pages long. We are, as Realtor members, we subscribe to the Code of Ethics of the National Association of Realtors. So this should not be a foreign document to you. The other one I want to point out is LIBOR's website. So in the event that you need to file for a dispute resolution, let me show you where you can find that. You're going to go to lirealtor.com. Go over to the legal section. Third one down is dispute resolution. And here it will explain everything we're going to talk about today. And if I click on the ethics here, it will take me down to ethics, and you can get your copy of the Code of Ethics right here. So this explains everything, all the services. And in the event you have to file a complaint or request for arbitration, this is where you would come to file it. But getting back to the PowerPoint, let's start talking about these committees. You have Realtor volunteers that sit on the grievance professional standards committees. We have approximately 60 people that sit on grievance. We have approximately 60 that sit on professional standards. Those who sit on grievance cannot sit on the professional standards committee. We have to keep them separate. And as I go through, it will become very apparent why. We have mediators. We have approximately 7 mediators here at the Long Island Board of Realtors. And we have approximately 6 ombudsmen. Now, I know it's a very odd term, but I will go through all of this with you. So let's start with the grievance committee. And let's start about what happens with disputes. What if you're having a problem out in the field with another realtor? What if you're had a closing and you didn't get paid your commission? What can you do? Going to court can be very costly. However, part of our membership and part of our code of ethics says that any disputes have to come before the Long Island Board of Realtors, and we settle them here. So that really takes away the cost of courts and the lengthy time that it could take with resolving disputes. So the grievance committee, the function of the grievance committee is to field the complaints as they come in. Our grievance committee meets once a month, and every month that they meet, they look at the complaints that have come in from the prior month's meeting. So who can actually file an ethics complaint? An ethics complaint can be filed by anyone. A member of the public can file against a realtor, or a realtor can file against another realtor. When it comes for requests for arbitration, the only ones who can file are the principal broker. The realtor principal broker can file. Now, I think what's important to know here, as a broker, I feel that it's very important that if any of my agents have any problems in the field, or if there's problems with ethics complaints or arbitration, that we try to settle these before we have to bring them before the Long Island Board of Realtors. I think the key out there is communication. So if you can get things settled before it has to come to LIBOR, I think that's the best way to go. But we do have these services available to you. So if you're in the position where you have to file an ethics complaint, or a broker files a request for arbitration, it will go before the grievance committee first. Ethics complaints deal with the perceived unethical action or conduct of a realtor. Now you can see I use the term perceived because everyone is entitled to a due process hearing, and yet they are not found in violation unless they have a due process hearing before the Professional Standards Committee. So our grievance committee is looking at the complaints to see if they fit within our code of ethics. When it comes to arbitration, Article 17 of our Code of Ethics deals with arbitration, and it has to be a dispute over monies from a real estate transaction. The transactions and complaints that we hear deal with the procuring cause side of the transaction. The procuring cause meaning the selling side of the transaction, where we have two brokers saying that it was their buyer that bought the property and that they are entitled to the commission. So these are the types of cases that we will hear at Long Island Board of Realtors. So who participates in the arbitration? It has to be filed by the principal broker, and it has to be principal broker to a principal broker of another firm. The realtor principals can file also, including their agents and or office managers. So anyone who has a financial interest in the outcome of the arbitration, when the principal broker files for the arbitration, can name these additional parties within their company. We also have the ability here to hear arbitrations between clients and their realtor principals. Now, I have been doing this since 1995, 2 years on grievance, and the rest of the years I won't even count up on professional standards. I have yet personally to see one of these cases. If a client wants to use our services, they have to agree to arbitrate before the Long Island Board of Realtors and panels of realtor brokers. So the first two are the more prevalent that we are seeing. So what does a grievance committee actually do? When you file that complaint with ethics or arbitration, they need to compare it to the Code of Ethics to see if it's going to move forward. And they are not judge and jury. They are not making the decision. And all grievance is looking at on the ethics complaint is they're looking at the formal complaint form, and they're looking at the narrative of what the complaint is. So based on that, if the allegations in the complaint are taken as true on their face, is there a possible violation of the code? If the answer is yes to that question, then the grievance committee will move it over to Professional Standards Committee for a hearing. If the grievance committee says, no, it does not fit in, they will dismiss the complaint at this level. I can tell you that the parties do have the right that if the case is dismissed to appeal that decision of the grievance committee to our board of directors, and the board of directors would have the final say on whether there is a hearing or the case is dismissed. It's very important for you to understand that we are firm believers in due process and want to follow the policies and procedures to the fullest. When it comes to arbitration, the grievance committee is going to make sure that it is realtor principal broker filed against realtor principal broker. And is it a dispute, a money dispute arising out of a real estate transaction? So it couldn't just be that a broker owes another broker money that they borrowed. It would have to be an actual real estate transaction that closes. So the grievance committee does ensure that what is filed is in its proper format, that they do get the complaint form, that they do get the narrative. They never look at any evidence that might be attached with it. They are confirming that the appropriate parties are named. And this is very important. The filing deadlines are 180 days. So with an ethics complaint, it has to be filed within 180 days of the alleged incident. With an arbitration, the property has to close and it has to be filed within 180 days of the closing. The grievance committee will also make sure that the Long Island Board of Realtors can put together an impartial hearing panel. But we do have a relationship with the New York State Association of Realtors, Hudson Gateway Association of Realtors, and New Jersey Realtors. So in any case, we can always feel confident that a case can move forward with an impartial hearing panel. When it comes to the ethics complaints, the complainant, when they file the complaint, will cite the article that they believe the respondent has violated. The grievance committee, when reading the complaints, has the right to agree to the articles that were filed, amend, add, delete any articles that feel, based on the narrative, that might fit into the code of ethics. So again, your grievance committee, your professional standards committee, your mediators and ombudsmen are all trained and retrained every year to the code of ethics and the procedures that can come down from the National Association of Realtors. So you are dealing with a high level of realtors that sit on these committees, and grievance, they are vetting them properly every month and either moving them forward or dismissing them. So this is just an overview, a visual of the way the process works. The complaints come in, they go to grievance if they feel it's going to need to move forward. It goes now to professional standards. It moves out of their hands completely, goes to a hearing panel. Hearing panels are going to be between 3 and 5 trained realtors that sit on professional standards committee. If the grievance committee dismisses the case for whatever reason, because it does not fit in the code of ethics, quote unquote there, then the person who filed the ethics complaint or the request for arbitration can send the appeal to the board of directors, and they say, we think grievance got it wrong. Board of directors would have the final say in that. So this is just an overview of what the process looks like. And again, please keep in mind, grievance does not make any determination, and they are only seeing the complaint side. So they're not seeing any evidence, and they're not even seeing the response from the other party. So what happens? Grievance decides to move that case forward to the Professional Standards Committee. Oh, and I want to point out that if you have any questions, please put them in the Q&A. I'm going to take questions at the end. I'll be happy to answer any and all questions. If you don't want to put them in the Q&A now, you can put them in at the end, but I will answer any questions that come my way. So when we move this case to the Professional Standards Committee, first of all, staff is behind the scenes. They are juggling these cases and have to get them onto a calendar. So they're the ones that have to coordinate the hearing panels. Everyone who's coming before the Professional Standards Committee is entitled to a due process hearing. The panel members that sit there must be fair, unbiased, and impartial, and they are there to determine if there was a violation of the Code of Ethics on an ethics complaint, or who gets the money in an arbitration case. So let me give you a little picture of what happens behind the scenes. I'll use myself as an example. Staff will send me an email saying, Linda, are you available on whatever date at a specific time to sit on an ethics or an arbitration? I'll check my calendar. If I'm available, I'll let them know. If I'm not, I'll tell them I'm not available. Once I tell them available, they will now send me only the names of the parties. Now, why this is important is that they want to ensure that the panel members can be fair, unbiased, and impartial. So if I see one of the parties that maybe I have had a dispute with, or I feel that I cannot be fair, unbiased, and impartial, I will go back to them and say, do not put me on the panel. And that's where it will end. If there's no issues, then we move forward, and they will do that with every panel member they're going to put on that specific panel. Also, the complainant in the case and the respondent in the case will get the list of everyone who sits on the Professional Standards Committee. And they have the right to eliminate up to a certain number off of that committee. So if there's someone on that list that the parties feel that could not be fair, unbiased, and impartial with them, they have the right to remove them. Now, they can't remove the entire committee, but they would specify why they would want that party to be removed. And again, this is very important because we want fair hearings. So before we get to the hearings, what's happened behind the scenes as well, the complaint has been sent over to the respondent, and the respondent now has had an opportunity to respond with their side of the story and any evidence and witnesses. So here at the Long Island Board of Realtors, we require that any evidence and witnesses be noticed to the Long Island Board of Realtors 10 days prior to the hearing. So any evidence must be in, and it must be made available to both sides. There's no surprises at these hearings. And we need the list of witnesses who are going to attend. The parties are also allowed to have representation by legal counsel. So if you want legal counsel to represent you, it is at your expense, but they are entitled to be there if you want them to be there. On an ethics complaint, realtors are also allowed to have realtor counsel. So realtor counsel are realtors who know the code of ethics pretty much inside and out, know the procedures. And again, the parties, if you want realtor counsel for an ethics complaint, this would be at your own expense. You also have the option to come to the hearings unrepresented. This is the choice of the parties. So I want that to be perfectly clear. The parties are the ones that make the decision on whether they want representation or no representation. So all of this is happening ahead of time before we meet. Now, as of today, we are still holding the hearings remotely through Zoom. But whether we're in person or through Zoom, the procedures are the same. The panel members receive ahead of time a copy of the complaint, a copy of the response, and all of the evidence that has been submitted. But what's very important to know is the panel members do not, and I mean do not, speak to each other about the case before the hearing is heard. We all need to go into these hearings wide open and not making any prejudgments. So on the day of the hearing, rest assured that your panel members have read the entire case and are prepared to hear whether it's an arbitration case or an ethics case, they are prepared for the hearing. So on the day of the hearing, this is a quick overview on how it works. The hearings, the length of the hearing will depend on the complexity of the case and how many witnesses there are and testimony. So overall, probably the shortest hearing I ever sat on was a half hour. The longest hearing I ever sat on went over a course of 2 days. So it depends on what the complexity of the case is. But this is a due process hearing, which will either be mechanically recorded or a court reporter will be there, depending on where the hearing is heard. Now, the purpose of the recordings is only in the event that there's an appeal on an ethics complaint or a procedural review on an arbitration, and I will discuss what those are all about in a minute. On the day of the hearing, each side will have an opportunity to present their case, evidence, and witnesses, and each side is allowed to cross-examine each other. So the complainant, respondent can present their cases. They are open to being questioned by the other party, and the panel members are allowed to ask questions of the parties at any point in time during the hearing. So there's opening statements by both sides, there's presentations by both sides, there's cross-examination, and I'm making this very simple at this point. And each side has the opportunity for closing statements. When the closing statements are done, then the parties will leave the room or leave the Zoom, and who is left behind will be the panel members. And also we have board counsel that attends the hearing and a staff person from our professional standards committee. The people that will be making the decision are the panel members. Board counsel is there to answer any procedural questions, and staff is there as well to help us with that. Once the parties leave the room, then the panel members will start their discussion. This is the only time where the panel members now openly discuss the case with each other. So we have two things that we have to talk about here. Let's start with our ethics complaints. When it comes to an ethics complaint, if we find that the respondent is not in violation of the code of ethics, then we do write up a brief report and we are done. But what are we looking for in an ethics complaint? So we go into the hearing with this in mind, that the respondents are considered innocent unless proven to have violated the code of ethics. The burden of proof is on the complainant to prove their case, and it has to be by clear, strong, and convincing evidence. So it's not that 5149 where somebody's sitting on the fence and it could go either way. Clear, strong, and convincing. So if they're not in violation, our job is done. If they are in violation, and the vote is always by the majority of the panel members, it does not have to be unanimous. If they're in violation, that is the first vote after great discussion that we will take. Once we decide they're in violation, then staff will inform us if there have been any prior violations that have come before the committee. So we are only looking at violations, not past complaints, violations. That will play into the sanctions. And these are the common authorized disciplines that we can work with. We can give a letter of warning. We can give a letter of reprimand. We can fine up to $15,000. That's a lot of money. We can require attendance to educational classes, not just one, could be a number of them. We can suspend or terminate membership with the Long Island Board of Realtors, and we can suspend or terminate services, including MLS. If it gets to those last two, it would be a really severe, very severe. But this is not a cherry pick list. This is not like we just pick one off the list. We could give a letter of warning and a fine and educational classes. So these are the common disciplines that we have to work with. Once we have submitted this out there to the parties, any decisions that come out of the hearing panels do have to be ratified by the board of directors. The board of directors does read the report that comes out of the panel, and they will see the sanctions. They are not allowed to raise up the sanctions. They can keep them the way it was presented to them, or they can lower the sanctions. But the board of directors does not have the right to raise up the sanctions. So what comes out of the panel is what gets presented to the board and ratified. The parties do have the right to appeal on an ethics. They can appeal because they feel that the panel members got it wrong. They misinterpreted the code of ethics. They could appeal because there was a procedural error that took place during the hearing. Or they could appeal because they believe that the sanctions, the discipline was too harsh. The punishment didn't fit the crime, so to speak. So that's the right to appeal. If there is an appeal, then it gets heard by members of the board of directors who would make the final determination. So that's a quick synopsis on the overall for the ethics complaint. On arbitration, so let's take our hat off now with the ethics. On arbitration, again, we're realtor principal broker to realtor principal broker. The panel will determine who is the procuring cause. And procuring cause could take me hours to explain, but it is the uninterrupted sequence of events that made the buyer want to buy the property. And your panel members sit there and will hear all testimony and have to determine overall who they felt was the procuring cause. So the award of the monies will go to the prevailing party. And again, it is by majority decision. The amount that we award cannot be more. We can't say, oh, they did really badly, so we must give more money. It has to be for the amount being requested, or it could be less. And I say it could be less. Maybe there was a miscalculation on what the commission was supposed to be. And please keep in mind, there is only one winner in arbitration. So I've sat on, I can't even tell you how many arbitration panels over the years. And it could very well be that I think the procuring cause belongs to broker A. When we go into executive session, I may find out that my fellow panel members believe that it is broker B that is the procuring cause. So that is why we take a lot of time after the parties leave to discuss, hash out, go through the evidence, go through the testimony, and make a final determination. Now, this is really important to know because sometimes it's unanimous and sometimes it's not, which means we have difference of opinions on the panels, and procuring cause sometimes is not a subtle thing. Why it's important to know is I believe you should know that we're going to talk about mediation, and mediation in a minute could help alleviate a lot of problems in the field. But before I get to that, when the arbitration results come out, brokers do not have the right to appeal that decision. You can't go, boo-hoo, I lost the case. I'm going to appeal the decision. We have what's called a limited procedural review. If there is a broker that believes that there is a procedural error on the day of the hearing, then they can file and request a procedural review, which would go before the board of directors, and they would make the final decision on that. Now, please keep in mind that your grievance committee, your professional standards committee, trained, retrained, and retrained all the time. So we have strict policies that we follow. So I'm not saying there wouldn't be an error, we're all human, but keep in mind that typically when these cases are heard, they're going to stick. And that's where mediation comes in, right? We have mediation services. So we talked about grievance, our 60 plus members. We talked about professional, our 60 plus members. Mediations, we have mediators that were specially trained. I did my training at the National Association of Realtors, and mediation, I really believe in this, is a powerful tool to help realtors and their clients resolve disputes that might otherwise be arbitrated. When you go to arbitration, there's a winner, there's a loser. Mediation, completely different. So the mediation officer is a neutral third party. We work with the disputing parties to discuss the dispute and come up with hopefully an enforceable resolution. So in this case, we put everybody together. We have the mediator, we have both sides, and it's sometimes, believe it or not, an arbitration could be three brokers involved. There could be a listing broker, and then there could be broker A and broker B, who are two cooperating brokers. So we could have a mediation with three brokers and their agents in it. We currently are doing these through Zoom. But if we go back in person, either way, it's going to be the same. In a mediation, we are all in the same room or Zoom together. The mediator is there to help the parties along, help them along I'm going to bring up this. And what we do is we let them know, we explain the process. Everyone has an opportunity to speak. And the mediator's job is there to identify the issue. Yeah, the issue is the money. Somebody got paid or somebody didn't get paid. But sometimes the issue is deeper than the money. Mediation tends to be more emotional. This is the opportunity for everybody to speak, get out their frustrations, get out their anger, and listen to each other. Sometimes I'm finding a lot of misunderstandings. One broker thinks the other one was out to get them, and the other broker the same thing. And typically with mediation, it's the actions of the parties in the transaction that cause the realtors to get into this disarray. With mediation, everything is confidential. If it gets settled in mediation, then the parties do not have to go to a formal arbitration hearing where somebody else is going to make the decision. The parties make the decision in the mediation. It's not the mediator. The mediator is there to help them along. The mediator also offers within mediation private caucuses. So the mediator can speak separately with the brokers and their agents away from each other. So everything is kept confidential. And if the parties can resolve through it, that is the best thing. If the parties come to an agreement is drafted up, all parties sign off on the agreement. It gets sent over to staff, and then staff will cancel the arbitration. So it's really important to know it's a phenomenal process. Here are some basic differences between the two. There's costs for both. We're not talking big dollar differences. So that's not the thing. Mediation. We offer mediation if a broker closes on the property and calls up LIBOR and says, I'm going to file for arbitration, but can we get a mediator? LIBOR will get them a mediator. Once they file for arbitration, it goes through grievance, and grievance is going to push it along. Mediation is going to be offered again. And if anybody needs it along the way, you let LIBOR know. I did a mediation once where I met with the parties and we couldn't come to an agreement. And I touched base back with the parties and said, hey, what do you want to do? And a couple of days later, they came to a resolution. So there's no right or wrong with mediation. The parties control the outcome. You have control over the outcome. We don't know if it's going to get settled in mediation, but rest assured, if it doesn't get settled in mediation, it's going to go to arbitration. Mediation can help with relationships. When we were doing in person, I had two parties hugging each other at one point in time, because a lot of times we think that somebody did wrong, but they didn't. They got misinformation just like we did. Arbitration, strict. There could be a moderate to long delay. Just think that this has to go to grievance. And if grievance just met yesterday and you filed today, your case isn't going to grievance till next month. And then once it goes to grievance and grievance moves it along, then we're waiting for the response. And then staff has to get it onto the calendar. And then hopefully there's no delays getting heard. So your arbitration could be months away, could be longer than months away. There's no telling when that's going to happen. And in arbitration, you're going to have a winner, you're going to have a loser. There's no splitting. There can only be one procuring cause. The panel members determine the outcome. And as you could see from my description, I've been in panels where the panel members don't agree. So, and I say this all the time in mediation. I say this separately when I go into private caucuses with the parties, because they sometimes get a little huffy, and I get it. I'm a broker too, and everybody thinks they're right. But just because you're right doesn't mean you're going to win. So if you keep that in mind, please keep an open mind if you find yourselves in an arbitration and going to mediation. Hopefully I'm sitting in the back of your head and say, yeah, Linda said, just because I think I'm right doesn't mean I'm going to win, because you're putting your monies in the hands of panel members. So, and they are trained, but not everybody sees things the same way. So mediation, I believe in the process. The parties are in charge. And we're going to get to questions momentarily. I do want to get to the next one. So as you can see, I love this whole process. But what happens with what other services do we offer here? So we talked about grievance, we spoke about arbitration, we have mediation, but we also have what's called ombudsman services, a very strange name, I understand. I abbreviate it to ombuds, or I'm an ombudswoman, but ombudsman services. And we have been very successful here at the Long Island Board of Realtors with these services. I understand that we can settle 80% of what becomes before our ombudsman. So we have about 6 ombudsmans out there. And what is an ombudsman? It is an individual appointed to resolve disputes through constructive communication and advocating for consensus and understanding. Well, what does that mean? So this is how it happens behind the scenes. Someone will call up professional standard staff and say, I want to file a complaint against a realtor. What staff will do is they say, well, if you'd like, we have realtors who are trained to try to help the situation. Would you like to speak to one of these trained realtors? They do not have to accept the services. If they say yes, then staff will reach out to one of the ombudsmen and say, please, can you handle this? With these services, we do not put the parties together, and I'll explain in a little bit. So the primary role of the ombudsman is to open up communication, conciliation, but we are not judge and jury. We're there to anticipate, identify, and resolve misunderstandings and disagreements before it turns into a full-blown ethics complaint. What we're trying to do is help the parties resolve whatever issue is there. We're not there to determine if there is an ethics violation. We're not there to determine who should get the money. That is not our job. Even though I might be thinking some of this stuff, never will come out of my mouth. Our job is to say, we've got a problem here. Let's see if we can fix the problem. We can deal with general questions about real estate. We do end up getting into the transaction details. We'll be told what the problem is. We may be asked questions about how we enforce our code of ethics here at the Long Island Board of Realtors and what the code of ethics is all about. And we can answer pretty much any questions and complaints about members. So how this typically works is the ombudsman will reach out to the complainant and find out what their complaint is all about. And once we have an understanding of what they're complaining about and what it is that they're looking to do to resolve it, then we will reach out to the realtor member and have a discussion with them away from the complainant and discuss with them what we're hearing the issue to be, and move it from there. And hopefully by that communication, we can overcome any misunderstandings, open up the door to communication. So we can handle things like the The seller lists their property and now their listing agent has gone AWOL. The seller's calling them, they're not responding, and the seller has no idea what we're doing. We can jump in on that. We can jump in with two realtors that maybe one is out there bashing the other one on social media. We can jump in on that. We're not here to help like a buyer with their short sale transaction. We don't get involved with that. We're here to help resolve complaints before they have to get filed and before they go into a hearing where a panel is going to make a decision if there's a violation or not. So again, I'm hearing 80% effective with this. So complainants do not have to accept our services, as I said. And if the complainant has filed the complaint, they've already filed the complaint, and they then at that point say, sure, I'll speak to somebody, the ombudsman will come in and try to resolve it. So if the ombudsman can resolve the complaint, the realtor agrees to the resolution, the complainant at that point can withdraw the complaint. However, if the realtor does not live up to the resolution, the complainant would have the right to come back and resubmit the original complaint if the realtor is refusing to agree to the resolution. So the complainant still has that protection in the event the realtor says, okay, I'll do this, this, and this, and then they don't comply with it. So the ombudsman, this is 100% confidential. In fact, we do not go back to staff and tell them any results with this. And with the ombudsman and with the mediation in those services, I have a shredder. Everything that I write down gets shredded. In mediation, we have to let staff know the results because they have to know whether they're moving things to arbitration or not. With ombudsman, we just let staff know that we dealt with it and that's it. So we cannot refer concerns. We can't go to the grievance committee and file a complaint. We can't go to New York State Department of State and and file a complaint. And we cannot go to any other regulatory body. Because we could also hear complaints regarding the public trust, which would be Article 10, dealing with fair housing and discrimination. So we as ombudsman are allowed to hear those type of complaints. If they are resolved at this level, then that is the end. It goes nowhere. And the reason is, we want to make sure that this prohibition ensures impartiality and confidentiality and avoids the possible appearance of bias. So this is truly confidential and goes nowhere. Once we are done with this. So one other thing, just to give you a note on our code of ethics. I'm going to just stop sharing the screen. On our code of ethics, please keep in mind that if you're going into an ethics hearing and are found in violation, that the results are confidential as well. It is only goes to the board of directors, and that is it. However, Article 10 is a different story. Article 10, if it's violation of the public trust and you're found in violation of Article 10, then the Long Island Board of Realtors is required under our Code of Ethics to report it to New York State Department of State, and then they will do what they feel necessary. When it goes into an ombudsman situation, regardless of what the complaint is, if it's resolved at the ombudsman level, that is where it ends. So those are our services that we have among other member services that are out there. Grievance, professional standards, our hearing panels, our mediators, ombudsmen are specially trained, and the training for your mediators is completely different training than those for your ombudsman. But please rest assured that your realtor, your fellow realtors who sit in these positions know what they're doing. We have wonderful staff that is behind the scenes. We got Marianne and Danielle that are there to take care of us, just like all the wonderful staff here at the Long Island Board of Realtors. And we have board counsel that sits in on our hearings. So we are fully represented. We follow all the requirements. And if you've ever seen the Code of Ethics and Arbitration Manual, it's quite a few pages thick. So I am happy at this point. I don't know if there's any questions out there at all, that if you're happy to put them in. Oh, I see one from Laurel. So Laurel is asking, how quickly does an ombudsman reach out to a complainant? Does a complaint have to be filed prior to an ombudsman engaging with the complainant? Great question, Laurel. I'm glad to see you're here too. So once I can tell you, once staff gives me someone and then the ombudsman, I'm on the phone with them in less than 24 hours. Usually it's a matter of 3 or 4 hours, but depending on the time of day and depending on my schedule. And the answer is no, a formal complaint does not have to be filed for you to use ombudsman services. And one thing I forgot to point out, there is $0 fee for the ombudsman services. So we are here to help all of you out in the field. If you, and again, I'm hoping the first level is that the brokers, office managers can resolve whatever complaints are out there in the field. But rest assured that we have these services where we can jump in to help you with the resolution. We don't want to see our members come in to these hearings and then be subject to having fines out there. We would rather have it all resolved. But great question. Are there any other questions out there? And I believe Marianne and Danielle are here. Oh, so if you want to throw questions in, that may be something I missed. So I see Jennifer. Welcome. Hi, Jennifer. So the question is, do we discard the last year's Code of Ethics since we have a new one? So that's very interesting, Jennifer, because, well, I seem to hold on to all of them, and all of them are always posted at nar.realtor. When a complaint is filed, I'm going to use this example. If a complaint was filed in December of 2022, but we have not heard the case yet for whatever reason. Now we're in 2024. When we sit on that panel, we are using the Code of Ethics from 2022. So at the time the complaint is filed is the Code of Ethics that we are using. So right now we're in January 1st, 2024, and our Code of Ethics from 2023 to 2024, there is no changes. We had some administrative changes behind the scenes, but the actual Code of Ethics that is on the website is there in the entirety, looks the same as it did in 2023. It's the first year in a very, very long time we had no changes to the code. So great questions. And any other questions here?
Thank you so much for presenting for us, Linda, and thanks everyone for joining. And this will be on lirealtor.com/webinars if anyone wants to watch it over again.